This is a summary of the public meeting held at the Fort Collins Public Library December 11, 2014. It is an update on the investigation and the appeal filed in the case of Benjamin David Gilmore.
Here's our schedule. We're going to do new evidence first, then we'll do an update on the 2014 fires that happened in Midtown Fort Collins. We'll have the presentation of the appeal by Mr. Fielder. Then we're going to watch the trailer for the next documentary film, and we'll have a summary, and then of course the best part I always like is audience questions. I want to start by thanking the law enforcement officers, firefighters, attorneys, all the court personnel who have professionally and expediently fulfilled open records requests and criminal justice requests. And this presentation is just a basic introduction to new evidence that has been uncovered in the past year in case 11 CR 1575, and in-depth coverage will be given in the documentary film that will be released soon. The documents that I'm using for this evidence is the Department of Justice, the Fort Collins Police, Hoodoo Fire Authority, official court transcripts, the Lane County Sheriff's Department in Eugene, Oregon, and the Downtown Development Authority minutes. To protect the integrity of this case, the speakers tonight will avoid opinion and speculation on our behalf. So our point in being here tonight is to show you the evidence, and then you can decide for yourself. All right, a few legal definitions for clarity. Justice is defined by Black's Law Dictionary as the fair and just administration of the laws. Exculpatory evidence is evidence that tends to establish a criminal defendant's innocence. That has to do with Brady material. Brady material is information or evidence that is favorable to a criminal defendant's case and that the prosecution has a duty to disclose. A hypothesis can be said to be valid only when rigorous testing has failed to disprove a hypothesis. So question number one, what evidence did the district attorney keep from the jury? And as we go through this, try to imagine that you are a jury member and weigh the evidence as it's presented here tonight and see if you can come up with a verdict at the end. So this is some of the evidence that the jury was not shown. The prime suspect's record that he threw Molotov cocktails in Oakland, California riots. The prime suspect's recent assault on a peace officer who testified at Gilmore's trial. The prime suspect's interrogation video that was recorded on the day of the fire by Fort Collins police officers. The second person of interest had a criminal history of arson and trespassing. The jury was not allowed to see that. And the defense expert witness on fire scene investigations and his testimony related to the Rolex watch was not allowed. That defense expert witness had a PhD in metallurgical sciences, and he was specifically prevented from testifying about his expertise in metallurgical sciences. Witnesses with ties to Brinkman Construction testified at trial that the job site was clean and secure. However, police records show that the job site was not secure. Women's undergarments were found in the building, and trespassing was documented on scene 2 days prior to the fire. What is NFPA 921? It's the standard of care in fire scene investigations. The foundation of NFPA 921 is the scientific method. So here's another way to think of it. NFPA 921 is to arson as DNA is to murder. Specifically, if the cause of death is a suicide, then it's not possible to charge somebody with murder. That's a pretty simple way to look at it. If the cause of the fire is accidental, natural, or undetermined, there is no way that a person could be charged for arson. Makes a lot of sense. ATF fire scene investigators testified that they determined arson as the cause of the fire prior to any laboratory testing of materials that were related to the fire. So that's a major flaw in their procedure from the beginning. The trial judge has to act as a gatekeeper. He has to determine that the investigative methodologies employed and the conclusions that were reached in the case are both relevant and reliable. And the judge has to confirm that the investigation was conducted in a scientifically valid and verifiable manner. So what happened to suspect number one? Gerardo Giovanni Salazar, also known as Clutcher and Jerry, he was identified in a lineup on the day of the fire by an arson detection canine. He had a history of making Molotov cocktails and using them in riots in California. He had recently pled guilty to a bias-motivated crime. He had recently been charged with assaulting a peace officer. He told detectives he would fail a lie detector test if they asked him about the fire. He also told detectives various stories about where he was when the fire started. First he was at the river, then he was at Horseshoe, then he was at the scene of the fire, and then he was at Occupy. He told detectives he was joking about starting the fire. He told at least 4 people that he started the fire. He told at least 2 people prior to the fire that he was going to save bottles to make Molotov cocktails. He told detectives he makes Molotovs out of a 40, gas, and a rag. And a 40 is a bottle, that's the size of a liquor bottle. Detectives allowed Mr. Salazar to leave town even though he was their #1 suspect. He had a history of arson. He was on probation for a bias-motivated crime. He told inconsistent stories of his whereabouts at the time of the fire. He told multiple people in different places and at different times that he started the fire. He was identified by an arson detection canine as having accelerants on his clothing and personal items. He claimed to set the fire at Mason Street Plaza on October 24, 2011.
Again, my name is Gary Fielder. I'm an attorney from Denver, and I'm basically a trial attorney, but I do a wealth of appeals. I've done appeals. I argued in front of the Supreme Court, 10th Circuit, and Court of Appeals. And writing one of these briefs, for any of you who have ever done it, is a labor, believe me. It's very difficult. And I just want to tell you a little story about what we've been going through. Now, first, let me start by saying it's very unusual for an attorney to be standing up in a public forum talking about a case which is still active. So I want to make sure that everybody knows that I'm an officer of the court. My first duty is to the court, and so I would never say anything out of school. I would never criticize a judge or criticize a district attorney or another attorney. I'm not here to really do that. I'm just here to talk about what's in the record and what we've seen in the record that causes me some concern. Not only on appeal, but for what might be post-conviction motions if we're not successful at the appeal. So I want to thank Law and Stacy, because I would come in and I would give it 4 or 5 hours, but they had the summaries ready for me. They had already gone over it, and we sat there and literally went over every single transcript. So I speak with some authority, 25 years of experience, over 400 jury trials myself. So after having reviewed the transcripts, it became very clear to me that the appeal is only one source of relief. You have to remember that if a jury finds someone guilty and you file an appeal, you don't just go to the Court of Appeals and say, Your Honors, let me show you some evidence, and I've got some new evidence, and could I call a couple of witnesses? You really don't do that. It's mostly briefing, and it's primarily, if not only, concerned with any error that the judge made. If we lose at the Court of Appeals, we can file a writ of certiorari with the Colorado Supreme Court. They can take it or not take it. It's up to the court. But you have a right to appeal. And in that sense, you have a right to a public appeal. The briefing is public. You can see the brief. You could make a copy of it and review it yourself. So nothing that I'm talking about is not in the record. In this case, the public defender, Mr. Gilmore's attorney in the second trial, objected to the complicity instruction and won. The court did not allow the district attorney's instruction on complicity. So, after that argument, and you typically argue out of the presence of the jury, you go through hours of arguing jury instructions. After that particular part of the argument, the district attorney said, well, I think it's appropriate that I still be able to argue it on closing argument. And the judge looked over to Mr. Gilmore's attorney, I'm just not making any value judgments, just telling you what's in the transcript, and asked Mr. Gilmore's attorney, well, what do you think? And his attorney said, yeah, that sounds fair to me. And if you don't know what I'm talking about, you're talking about one of the most extraordinary errors I've ever seen in my life. If the jury doesn't know the elements of complicity, all of which must be proven beyond a reasonable doubt, then how are you going to allow the district attorney to argue complicity on closing statements? The irony was that by the public defenders sort of trying to establish that Clutter did it, all that did was establish complicity between Clutter and Mr. Gilmore, because he had worked for Mr. Gilmore. That was the theory behind how was his watch at the scene. Well, it was stolen. Who was it stolen by? Likely Clutter, because he had access to his house, his car. Maybe it was stolen by Clutter and sold and given away. You don't know. Now, I can say that it is my humble, heartfelt, deep conviction and belief that Benjamin Gilmore is innocent. So they had witnesses that said that he had engaged in this fire spinning, and they had a witness that was there the night he got hurt, and they put bandages on it, and the like. And so I know that the focus was on Mr. Gilmore. But once they jumped to that conclusion, within 9 days after this fire, the ATF had determined that it was arson and that it was Mr. Gilmore. The expert opinion that was rendered 9 days after the fire was 6 sentences long. 6 sentences within a half-page report. And that night, Clutter told the police it sounded like someone was shooting something. So he was making the same comments as the people in Penny Flats were making. It was sounding like shotguns. It was sounding like shooting. So that meant he was there. He admitted to seeing the fire and walking away. Whether he did it or not, it's not the point. The point is, he's an alternative suspect. You've got to be allowed to argue your alternative suspect. And for whatever reason, the court did not allow the jury to hear the DVD, and I thought it was critical. This is an arson where there's 6 sentences with regard to the finding of arson, not even close to what's required in 921. 2 trials, 2 sets of counsel, no Daubert motion, no Schreck motion. But the primary arson investigator testified that the fire started on the 3rd floor. Well, Law's done the graphics work. It's clear that the 4th floor is on fire when the transit video goes right to it. The 3rd floor is not on fire. I could sit here for an hour and tell you 100 things that I picked out of this transcript that are highly problematic. However, you must understand this. In the Court of Appeals, you can only really talk about errors that the judge made. And we've got 5 of them. We had about 12, but you've got 9,500 words, and we filed a brief that had 9,499. So we picked the 5 that we thought were the best. Those only focus on the errors that the court may have made. The 2 primary being not allowing the jury to see the Clutter video and allowing the district attorney to argue complicity after specifically denying the complicity instruction, and 3 others that we think are meaningful but maybe not as strong. If the Court of Appeals says no, these may have been errors but they were harmless or they didn't impact the fundamental fairness of the trial, the verdict could be sustained. Now, it's not unusual, so I'm not talking out of school, but it's not unusual that if you lose a Court of Appeals case, you try to go to the Supreme Court, and if you get in the Supreme Court, you're there for another year. But if cert gets denied, you go back to the district court. It's not speaking out of school to say that in many big cases where a person goes to prison for a relatively lengthy period of time, that you might file a motion for a new trial based upon ineffective assistance of counsel.
Where's the blue one? Come on, the blue one. What color is that?
Benjamin is serving a sentence of 8 years at the Kit Carson Correctional Facility in Colorado. As of the date of this meeting, He has been incarcerated exactly 1 year.